Truth on Trial, The Legacy of Elizabeth Loftus by Elizabeth
Lyndia, Zheng,
and Shreya, Chellu.
I never intended on becoming such a controversial figure. I was a scientist, curious, fascinated by memory. But the deeper I looked, the more I realized memory isn't a recording, it's a reconstruction. And in the courtroom, that reconstruction could destroy lives. That realization set me on a collision course with the justice system, the media, and the public itself. This is the story of how unintentional questions shook the foundation of criminal law, about my responsibility to protect the rights of the accused, and how truth, real truth, is more fragile than we think. In 1974, I published a study with John Palmer called The Reconstruction of Automobile Destruction. It started with a simple question: how reliable are eyewitness testimonies? Let me show you how it worked.
Good morning, class. In this study, we asked participants to watch a video of two cars in a minor crash. Then, we asked them how fast the cars were going, but changed just one word in the question: hit versus smash.
People who heard the word smashed not only estimated that the cars were going faster, but they were also more likely to say they saw broken glass when asked a week later.
But there was no broken glass, none.
What we found was astonishing. The wording of a question could alter memory, not just what they said they remembered, but what they actually believed they remembered. This was a new memory, created by suggestion.
Your memory isn't a video recorder. It's a story that your brain writes and then rewrites based off of what you're told, what you feel, and what you expect. That one word, smashed, uncovered a truth about memory that we just couldn't ignore.
All right, class, that's all for today. I'll see you next week. Don't forget to do your homework.
My research challenged the very foundation of how courts use eyewitnesses. Because if memory can be shaped, distorted, or even implanted, how can we trust it to put the right person behind bars? I felt it my responsibility as a scientist to ensure the rights of the innocent aren't stripped because of a faulty recollection. During this early time in my career, the 1970s, America was disillusioned. Watergate, Vietnam, trust in institutions crumbled. Society was ready to challenge traditional systems, and my research was well accepted.
Peace now, stop the bombing, stop the war.
US out of Vietnam, power to the people.
But then, during later points in my career, like the 90s or late 2010s, the tide shifted.
My name is Lynn Crook, and I'm a survivor of childhood sexual abuse. In 1994, a Washington state judge ruled in my favor, and I was awarded $149,000 in damages. Despite all of this, Elizabeth Loftus, who has never met me, told the media that my case was based off of false memories, supposedly planted by my therapist. That's false. My therapist never suggested abuse, and my siblings corroborated my memories. Loftus has testified for Harvey Weinstein, Bill Cosby, Ghislaine Maxwell. She called it science, I call it a betrayal. Her work has been used to protect predators and discredit survivors. She didn't just disrupt my case, she has silenced millions, and I will not be silenced.
My name is Ethan Waters. I'm a journalist who spent years studying how memory shapes and distorts our lives. The recovered memory movement of the 1980s and 90s was, as Harvard's Richard McNally puts it, one of the worst catastrophes to befall the mental health field since the lobotomy era. The movement quickly spread throughout social media and the internet, and Dr. Loftus helped fight against the spread of this misinformation, as there was simply no science that supported this type of retrieval and repression. For asking whether a memory could be false, she was vilified. But her research has saved innocent people from prison and reminded us that our memory is not infallible. She defended both victims and science when both were under attack.
I've been a target of vitriol and an object of adoration, a misogynist to some, but a clear voice in the darkness to others. But I felt a sense of responsibility to continue fighting for what is right, to protect the defendants falsely accused of crimes they didn't commit through my expert testimony, to inspire initiatives like the Innocence Project, working to exonerate victims incarcerated by faulty eyewitness accounts, and furthermore, to protect the public as the real criminal runs rampant as we convict the wrong person. In courtrooms, eyewitnesses can sway jurors in the absence of DNA evidence. Now let's step inside them. Let's start from the beginning. Witness, please close your eyes. Who did you see the day of the mugging?
I swear I saw your client. I could never forget the face. I had plenty of time to observe, and there were no obstructions.
And was this man holding a weapon?
Absolutely, I saw him pointed right at the victim.
And did he have a scar on his arm?
Yes, I saw it. It was near his elbow.
Jurors, this is what Dr. Elizabeth Loftus would call a leading question. The witness here wasn't asked, can you say for certain if you saw a scar on his arm, but instead, did you see a scar on his arm? Leading questions plan to see a false memory. In 1975, Dr. Loftus published a study on this exact subject matter. Participants were asked a leading question. Did you see the barn? And they recalled seeing a barn that didn't actually exist. In 2002, she challenged repressed memories. And in 2009, she demonstrated how entire false memories could be implanted. Her work has been cited over 90,000 times. So, if the witness here cannot clearly identify my client, who does not have a scar on his arm, how can we trust that she really did see him that day? Dr. Loftus isn't saying that your memory is useless. She's saying that you're human, and humans make mistakes.
This case exemplifies how my work has shone a light on the unreliability of eyewitness testimony and identifying the right perpetrator. Because if memory is so malleable and so susceptible to outside influence, how can we trust it to do such an important job? And that's exactly why I've dedicated my life and career to research and educating the public and legal community about memory. Now, let's take a further look at my impact on the legal community.
Good afternoon, Professor Smith.
Please call me Abby.
First of all, can I just say, it is such an honor to have the opportunity to interview you, a prolific, lifelong criminal defense attorney and professor at law. So, you mentioned in your email that you're aware of the challenges of eyewitness testimony, especially pertaining to the power of jurors.
Thank you for reaching out and thinking to include my perspective in your article. I just want to say this. The reason why eyewitnesses are so powerful in a criminal trial is because if you think about it, more than any other institutional player, they share the most in common with jurors.
Right, jurors are randomly selected from the community.
Exactly, and eyewitnesses are in the same randomly selected situation. They didn't wake up in the morning and think to themselves, gee, I'd love to be a witness. No. Instead, as a result of, being someplace at a particular time, they ended up becoming bystanders or witnesses. This similarity causes jurors to place a lot of trust on eyewitnesses, and this is precisely why Dr. Loftus' research is so crucial.
I know you've analyzed the case of Ronald Cotton, who spent 11 years in prison because of a single eyewitness. Can you explain how systemic factors contributed to his wrongful conviction, and why exonerating him was so difficult?
You know what makes a conviction so hard to challenge?
What?
Once someone is found guilty, all of the rights we rely on before and during trial, presumption of innocence, proof beyond a reasonable doubt, they vanish.
Isn't it true that 69% of DNA exonerations involve eyewitness misidentification?
Absolutely. It's the leading cause of wrongful convictions and incredibly difficult to overturn.
Why is that?
Because they're factual errors, not legal ones. Appellate and federal courts focus on constitutional errors, such as, did the judge admit the wrong evidence, or were the instructions the jury received flawed? But identifying the wrong perpetrator, that's a factual error, and higher courts rarely second-guess the jury on facts. They defer mightily to fact-finder judgment, so once it's on the record, it stays there. Cotton's exoneration was lucky, because there was DNA evidence to prove the fact of his innocence over the fact of his guilt, decided by the eyewitness and jury.
Got it. Thank you so much for the information.
No problem.
Rights mean nothing without the people taking the responsibility to protect them, namely our right to a speedy and public trial by impartial jury, as embodied by the Sixth Amendment of the Bill of Rights. And taking responsibility begins with asking, how do we know what we know?
Memory is powerful, but it's not perfect, and justice depends on getting the facts right.
My research may not be comfortable, but justice shouldn't be comfortable. It should be accurate.
Rights should be protected through truth, not assumption. And it is our responsibility to question how justice is served.
Thank you.